A police officer tells you to unlock your phone. Most people do it. No questions, no hesitation. They hand over everything on that device in about 3 seconds because they do not know they have a choice. That is the most costly mistake you can make in that moment, and it is entirely avoidable. I am Ben, and today we are breaking down exactly what you say the moment a cop tells you to unlock your phone, why that one phrase protects everything on your device, and what the law actually says about whether he can make you do it in the first place. Because there is a phrase that covers you completely. It is short, it is calm, and by the end of this video you are going to know it. Let us start with what you actually need to understand about your phone and the law. In 2014, the Supreme Court decided Riley versus California. Unanimous decision. Every single justice agreed. Police cannot search the contents of your cell phone without a warrant. Not during a traffic stop. Not after an arrest. Not during any encounter where they happen to take possession of your device. The court said a smartphone is not like a wallet or a piece of paper you are carrying. It contains the entire record of your private life, your messages, your photos, your financial information, your location history, your medical records. The court held that searching that information without a warrant is the same category of violation as searching your home without one. That ruling means something very specific in practical terms. When a police officer takes your phone, the Constitution prohibits him from looking inside it. He can hold the physical device. He cannot access the contents. And telling you to unlock it so that he can access those contents is asking you to hand over the protection that ruling gives you, which is why what you say in that moment matters. Here is the phrase. You say it calmly and clearly. Officer, I am not going to unlock my phone. I am asserting my Fourth and Fifth Amendment rights. That is it. That is the phrase. You say it once. You do not argue. You do not explain further. You do not ask what he wants to look at or offer to show him something specific. One sentence, delivered calmly, and then silence. Now, let me explain exactly why those two amendments together give you the protection they do, because understanding the reason is what makes you confident when you say it. The Fourth Amendment protects you against unreasonable searches. Your phone is your private property. The contents of your phone are protected from search without a warrant. When you assert your Fourth Amendment rights, you are telling the officer clearly that you understand what the Constitution says, and you are not waiving that protection. The Fifth Amendment protects you from being compelled to be a witness against yourself. A passcode is something only you know. Providing it is testimonial. Courts have repeatedly held that you cannot be forced to give up the key to your own private information, because doing so is essentially testifying against yourself. The Fifth Amendment covers your passcode directly. Together, those two amendments create a shield around the contents of your phone that an officer without a warrant cannot legally breach. Now, there is a distinction that most people do not know about, and it is one of the most important things you will take from this video. The law treats your passcode differently than it treats your face or your fingerprint. A passcode is protected by the Fifth Amendment because it is something you know. You cannot be compelled to produce it. A fingerprint or your face is something you are. Courts have been divided on whether law enforcement can compel a biometric unlock. Some courts have said that forcing someone to place a finger on a sensor is no different from requiring a physical key, and that the Fifth Amendment does not protect it. Other courts have disagreed. The law is not settled the same way it is for a passcode. This means there is a practical step you should take right now, before any encounter happens. Learn how to disable biometric unlock on your phone. On most iPhones, pressing the side button 5 times rapidly activates emergency SOS and disables Face ID until you enter your passcode. You can also go to Settings and turn off Face ID entirely and require a passcode. On Android phones, most devices have a lockdown option in the power menu that does the same thing. If you are in a situation where you think police contact is coming, whether it is a protest, a stop you see developing, anything, switch your phone to passcode only before the encounter begins. Once your phone requires a passcode to unlock, your Fifth Amendment protection is at its strongest. An officer who wants what is inside that device needs a warrant to get it. Before we get to the scenarios, let us talk about the things officers say to pressure people into unlocking their phones, because knowing these tactics in advance is what keeps you from falling for them. The first one is, I just need to look at one thing. This is meant to make the ask feel small. He does not want to search your whole phone. He just wants to check something quickly. It does not matter how narrow he frames the request. The Fourth Amendment does not have an exception for quick looks. The contents of your phone require a warrant, regardless of how much or how little he claims to want to see. The second one is, if you have nothing to hide, you should not mind. This one is designed to make asserting your rights feel like an admission of guilt. It is not. Exercising a constitutional right is not evidence of anything. The Supreme Court has made clear that invoking your Fourth Amendment rights cannot be used against you as evidence of wrongdoing. Saying that phrase back to an officer means nothing about whether you are innocent or guilty. It means you know your rights. The third one is, I can get a warrant anyway, so you might as well just show me now. Maybe he can get a warrant. That is not your problem. If he can get a warrant, let him get one. The warrant process exists for a reason. It requires a judge to independently decide there is probable cause to search your specific device for specific information. That is not a formality. That is a constitutional protection. Your answer stays the same. Now, let us talk about the scenarios where this comes up, because the situation matters. Traffic stop. You are pulled over. The officer asks to see your phone, maybe because he suspects you were texting, maybe because he saw you recording. You do not hand it over without a warrant. If he takes it, you say the phrase, "Officer, I am not going to unlock my phone. I am asserting my Fourth and Fifth Amendment rights." He does not have a warrant. He cannot legally search the contents. After an arrest. You are arrested and your phone is taken as part of the booking process. The phone is now in police custody. They still need a warrant before they can search what is inside it. Riley versus California was specifically decided in the context of an arrest. The rule applies. Your phone sitting in an evidence bag does not give them the right to access its contents. During a street stop, an officer stops you on foot and wants to look at your phone. Same rule, same phrase. He does not have a warrant. Assert your rights. One sentence. Now let us talk about what you do if the officer takes the phone anyway, despite your assertion. You do not physically resist. You do not grab for the device. You do not create a confrontation over it. The moment this becomes physical, you have handed him a basis for a separate arrest that has nothing to do with your phone rights. Let him take it. Your legal claim remains intact, and it is stronger because you stated your rights clearly on the record before the phone left your hand. What you say before he takes it, if you have time, is this: I am not consenting to any search of this device. I am asserting my Fourth Amendment rights. If he has already taken it, say it anyway. Document it. Write it down. There is something else you need to know about what can happen after a phone is seized. There have been documented cases where officers used a detained person's face or fingerprint to unlock a seized phone without their cooperation or consent. If you believe an officer is attempting to use your face or your hand to access your phone without your agreement, state clearly that you do not consent to any biometric access of the device. That statement on record matters in any legal proceeding that follows. Also important is what law enforcement cannot do with your phone once they have it. They cannot hand it to a technician and start extracting data. They cannot plug it into a device to download your information. They cannot access your apps, your messages, your photos, or your location history. All of that requires a warrant first. The seizure of the physical object does not authorize the search of what is inside it. There is one more thing worth addressing about what officers sometimes attempt when a phone has been seized and they do not have a warrant yet. Some officers will hold a phone in evidence while working on obtaining a warrant, and during that window they may try to access the phone through technical means. Law enforcement has access to commercial tools that can sometimes extract data from phones, particularly older models or devices with known vulnerabilities. Keeping your phone updated with the latest software patches reduces the effectiveness of some of these tools. A fully updated passcode-protected device is significantly harder to access than one running outdated software. This is not a guarantee, but it is a layer of protection that costs you nothing. Take one practical step before any encounter to protect yourself. Set your phone to automatically back up your photos and videos to cloud storage. iCloud, Google Photos, whatever service you use. Turn on automatic upload. That way, any footage you recorded before your phone was taken already exists somewhere else. Your recording does not disappear with the device. After any encounter where an officer demanded your phone or asked you to unlock it, here is what you do. Write down everything immediately. Exactly what he said, exactly what you said, the time, the location, his name, badge number, patrol car number if you could see them, any witnesses. Do this while the details are still fresh. If your phone was taken without a warrant, and you believe it was searched, contact a civil rights attorney as soon as possible. An attorney can send a letter to the agency requiring them to preserve all evidence related to the seizure, including body camera footage and the chain of custody for your device. That letter needs to go out quickly. Here is the complete sequence for any encounter where a cop tells you to unlock your phone. Switch to Passcode if you have not already. A biometric unlock gives you weaker protection. State your rights once, clearly and calmly. Officer, I am not going to unlock my phone. I am asserting my Fourth and Fifth Amendment rights. Do not engage further. One sentence, and then silence. If he takes the phone, do not resist. State that you do not consent to any search of the device. Document everything immediately. Contact an attorney if the phone was taken or accessed. The law here is settled at the highest level. The Supreme Court looked directly at this question in 2014 and said your phone requires a warrant. 9 justices agreed. That protection exists, whether the officer in front of you knows it or not. Whether he respects it or not is a separate question. Your job is to assert it clearly, so that the record shows exactly where you stood. The officer who says unlock your phone is counting on the fact that most people comply before they ever think to question it. That compliance is what bypasses every protection the law gives you. Now you know what to say. The next time a cop takes your phone and tells you to unlock it, you know the exact words and you know exactly why they matter. One sentence. Assert your rights. And do not unlock that phone.